It's a dirty game out here. So Nike, we talking about Nike, the retail giant, Nike, the billion-dollar company owned by Phil Knight, recently lost a trademark battle, a trademark infringement lawsuit to a smaller company in Pennsylvania, apparel company, small apparel company in Pennsylvania, where Nike had to pay damages. But the big thing, and we'll get off all into the Forbes article that just broke today, where the court made Nike pay the attorney fees for the smaller apparel company to the tune of $7 million. So we're going to talk about it today. But I want to first introduce myself. I'm Dave, a 10-year intellectual property attorney dealing with everything from patents to copyrights to trademarks, trade secrets. And I recently broke out a video a week or so ago on my channel that talked about how T.I. and Tiny they won a lawsuit versus MGA Entertainment for the OMG dials that was based off a group of T.I. and Tiny's daughter. They had two other members. MGA Entertainment, it's a big company, billion. I think they got like $4 or $5 billion in revenue a year that they do, and they actually lost and have to pay what I think 80 something $million, 70 or $80 million to T.I. and Tiny for a trade dress infringement of these OMG dials, which the court awarded. So I'll post a video up, and I got a lot of comments on it. Go check it out if you haven't. I think it's go check it out. It's probably approaching 2,000 views or whatnot, so it's still climbing. But you had a lot of comments that said, "Hey, if T.I. and Tiny weren't millionaires, they wouldn't have been able to pay all this money and essentially win this case." So in other words, they were pretty much saying, "Hey, if T.I. and Tiny weren't millionaires, then they wouldn't have been able to get this large lump sum judgment that they got." And maybe that's true, maybe that's not true, but it almost kind of goes to a bigger issue for me as relates to, hey man, look at it. If you're going to get into business, number one, I always want to encourage you, and this is the whole point of this channel, to protect your intellectual property, whether it's trademarks, whether it's patents, copyrights, whatever it is, you need to protect your intellectual property. And to the extent that someone, whether it's a Nike, whether it's an Apple, whether it's a Microsoft, and don't want to point those big companies out, but regardless, if it's a big company that's infringing your intellectual property, you have to, try to resolve this thing amicably. But just because it's a big company and they're, again, a David Goliath situation, you got to be prepared to sue these people. You can't have this mindset of, well, it's a big company and we don't have the funds. And look at that. I think that's such a loser's mentality when you're going into, I can't even imagine that you're even going into business if you have this loser's mentality of, hey, we're going to lose to the big guy. They're going to bleed us dry. I get it. It's an uphill battle. However, to have that mentality, especially when and it's documented that somebody's doing something wrong, to still have that mentality to not want to fight back just because this company has so much more resources. Again, you have to do this thing strategic, obviously, but to the extent that the person is, this company is, again, committing infringement and it's cut and dry, and it's all right there to say, hey, I don't want to fight against the company and just lose. I just think that's such a loser's mentality, and I think you're not going to get anywhere in life. I actually did a video probably a month or so ago on my channel where it was a company out of Europe. She had like a salon and things like that, and she had a trademark that, again, unfortunately, she let lapse. Again, we're going to get off into this Forbes and this Nike trade infringement lawsuit, but I kind of wanted to take you guys along the long way. It was she had a trademark. I forget what it was, but she unfortunately let it go lapse. This is another reason why you want to get a trademark counsel or IP counsel on your team, because they're going to keep up with this stuff and make sure to give you these due dates so that you aren't in her situation where the company was growing, trademark unfortunately goes lapse because she kind of dealing with the day-to-day business and she forgot to file the trademark. So now it goes abandoned. She has to refile her trademark application. She essentially has to start all over again. And L'Oreal, a big company that sells hair conditioner and hair products and things like that, they are essentially trying to block her from getting her trademark. And she had to close shops, and she spent tens of thousands of dollars on attorney fees to try to fight with them. And she's probably going to win in the end. But number one, she would have never had that situation if she would have, again, had IP counsel on the team that would have made sure she renewed her mark. But number two, again, I have to respect for her, even though it's an unfortunate situation. I respect her and her business because she knows that she's in the right in this situation. Unfortunately, she had a lapse in judgment for the business, but she understands that, hey, this is her trademark. This is something that she built up, that she has had for a long time. She's not going to let, just because it's L'Oreal and it's $1 billion company, she's not going to let them come just take her trademark as a result of them making her spend more money. So again, kind of going back to this Nike situation and the T.I. and Tiny situation, just because you have a big company that you have to sue and they have deeper pockets. Again, this Forbes article that we're going to read gives hope to the little guy, because you can still come out victorious, as this little guy did. Nike has to pay them just short of $1 million, but more importantly, they have to pay the attorney fees for this small company, or the small company out of Pennsylvania, which is $7 million. So, and not only that, their trademark was upheld at court, which only makes the trademark even more stronger than ever. So again, it is a silver lining in all this. Let's get off into the article here, so we can see what tips we can learn from it. And again, please hit the like button if you haven't already, and subscribe to the channel to the extent that you haven't already. So let's go up to the top here. Nike stole company. Again, this is a Forbes article, so this is a pretty obviously Forbes is Forbes. Nike stole company's trademark, then tried to bury it in legal bills. Court order report says. Let me bring it back on myself. So again, big companies will try to do this, unfortunately. They'll try to stump on a little guy. Just because they have deep pockets, they're going to kind of take you through the ringer. Hey, that don't mean you should give up. So again, and this is a testament to them not giving up and end up coming out victorious on the other side. So shout out to them. But I told you guys that the district court ordered Nike to pay just short of $1 million and $7 million in attorney fees. Nike appealed what it looks like. Again, we're going to get off into the article, but Nike appealed what looks to be the $7 million of attorney fees, because they thought, hey man, that's a section. Attorney fees are typically awarded in exceptional circumstances, and those circumstances didn't apply in this case. Therefore, Nike is saying, hey, we shouldn't have been awarded this $7 million. Now, the Court of Appeals ended up essentially taking away the $7 million judgment. However, I mean, for the attorney fees, they still upheld the fact that it was trademark infringement, which is a good thing for the company, I think Lantex. But they also, they kind of said, okay, this $7 million doesn't seem right. It seems like these exceptional circumstances didn't apply, but they appointed a special master or special person to essentially look over things as it relates to with regard to the $7 million in legal fees. So again, as I pull back up the article here, when you see here, here we go right here. So when you see that the court order report says, the court order report, they just turned in their report to the court, the circuit court, the Court of Appeals. And again, the court order report seems to be siding with the smaller company. They're saying that Nike tried to bury this company in legal bills. So again, as talked about today is October 7th. It just came out earlier today, October 7th. Seems like at 8 o'clock. So let's read the article. In the classic David and Goliath case, a small Norristown, PA-based company, Lantex, was forced to take sportswear giant Nike to court over trademark infringement. Just because you got to take someone to court, especially if you know you're doing the right thing, this company is committed trademark infringement. Do not be afraid. And again, in this case, it seems like things worked out for them. So kudos to them. So a 2021 civil jury trial held Nike accountable for infringing a trademark and ordered Nike to pay a modest amount in damages, plus cover Lantex legal expenses due to exceptional circumstances surrounding Nike's unethical behavior and willful disregard of Lantex claims. Now on appeal, a court ordered review of the special circumstances that warrant Nike to pay the plaintiff Lantex nearly $7 million in legal expenses, found that forcing Lantex into a court to uphold his trademark was Nike's intent all along. So again, as I said before, this is at the Court of Appeals. The Court of Appeals initially, kind of reversed this $7 million, but then they said, hold on, let's appoint a special master to really look into this. And it seems like the special master is siding with Lantex and saying, hey man, it seems like Nike, they had some unclean hands in this one. They tried to, force this smaller company and essentially bleed them dry, force them into court, and prove prove the validity of their trademark, and try to essentially bleed them dry, bankrupt the company essentially. And it seems like Nike's plans didn't work. Number one, they were able to uphold their trademark. Number two, they got $7 million in legal fees as a result of having to defend their trademark and their claims against Nike. So it seems like this was a not so good day for Nike. So let's go back to it here. So it seems like, okay, so this is a retired Pennsylvania Supreme Court judge, Jane Cutler. wrote that Nike acted in bad faith through vexatious litigation. Vexatious litigation. She concluded that Nike intended to kill Lantex's business and lawyer fees, costs that Nike can easily absorb, but Lantex cannot. Nike did not respond to my request. So again, it seems like Nike was trying to bleed this company dry. Obviously, we all know Nike, they're doing hundreds of millions of dollars a year, maybe billions of dollars a year in revenue. So $7 million is small pennies to them, but they're trying to, and again, it's a dirty world. Hence, it's a dirty world or it's a dirty business. Big companies are trying to do that. So war lost, but Nike keeps fighting. In the original judgment, Nike was ordered to pay Lantex $791,000 in compensatory and punitive damages for essentially committing trademark infringement to the cool compression technology that supports muscle recovery, which Lantex sell under the Sweat It Out brand. So Lantex actually have at least two trademarks, one for cool compression and one for Sweat It Out. Again, the value of these trademarks, they have two trademarks, one for cool compression and one for Sweat It Out. Let's continue reading here. That award is chump change considering the estimated $100 million Nike made on this copycat version. So I'm not sure what's going on here. I haven't read the lawsuit, I must admit, but the fact that they only got $791,000 when Nike made $100 million on this copycat version is crazy to me. Obviously, it has to be more to the story, but just reading here, again, that award, again, the $791,000 that Nike was ordered to pay Lantex for essentially trademark infringement of the cool compression brand as well as the Sweat It Out brand or trademarks. They the article is saying, hey, man, that's chump change considering that Nike made $100 million on essentially the copycat version that Nike was selling, which is crazy that Nike only had to pay $100 million. I had to look at this article. I mean, the complaint, because that's crazy that they were only awarded $791,000 even though Nike made $100 million. Something doesn't add up with that. I had to check into it, but that's what the article says. So Nike was not held accountable for Lantex's lost profits due to its trademark infringement. However, it was ordered to pay Lantex's legal fees, something not typical in a trademark infringement case. So essentially, they're saying, hey, with trademark infringement cases, you typically don't have to pay the other side's attorney fees, but given the nature of this case, the district court required Nike to pay the attorney fees, which amounted to $7 million. But they weren't, which is crazy to me that they didn't have to pay Lantex's lost profits due to its trademark infringement. So the trademark infringement happened. That's not up for debate. Nike committed trademark infringement against Lantex. This is just according to the court. And as a result of the trademark infringement, they had to pay $791,000 in compensatory damages and punitive damages. That's crazy that the punitive damages weren't more. We just saw that T.I. and Tiny case. MGA Entertainment had to pay what? I think 50-something million, 70, either 50 or 70 million in punitive damages to punish MGA Entertainment for the nature in which they went about it. And in this case, the court only awarded $791,000 for compensatory damages. That seems like a very low amount given the fact that with the special the special appointed person said that this thing was essentially Nike acted in bad faith. So that's crazy that they only had to pay $791,000 as a result of that. Again, it seems like they didn't. Again, it seems like the attorney for Lantex wasn't able to prove lost profits. Yeah, that's mind-boggling. Okay, let's continue on here. On appeal earlier this summer, the Third Circuit Court in Pennsylvania determined the trademark infringement proceedings were conducted fairly and upheld the judgment, but it reversed the order to pay Lantex's legal expenses, finding that the exceptional circumstance exception doesn't apply in this case. So it seems like the Court of Appeal said, "Hey, we're gonna uphold the judgment or essentially the judgment of the district court." However, this whole thing about Nike having to pay the attorney fees, that seems a little bit far-reaching. So they reversed that. However, the court called for a special master to review that ruling. So Judge Greenspan, essentially got the call, this retired Supreme Court judge in Pennsylvania, and just submitted her report arguing that forcefully that Nike outrageous behavior meets the very definition of exceptional. So again, this special master is saying this exceptional circumstance did apply in this case based on Nike's outrageous behavior. In other words, she's for the little guy saying that Nike should have to pay the $7 million. Let's go to this reckless indifference. Lantex originally registered its trademark for cool compression technology in 2008. So they've owned its trademark for 16 years, selling its sports apparel under the Sweat It Out brand to its sports team and consumers. In 2015, Nike started offering compression clothing under its Nike Pro brand using the term cool compression to describe it. So again, 7 years later, Nike is essentially trying to, or not trying to, essentially Nike has committed trademark infringement of the cool compression trademark. In April 2016, Lantex got wind of this trademark infringement and sent a cease and desist letter. You always need to send a cease and desist letter. Nike lawyers directed the company to stop using the phrase as soon as possible. However, the company dragged its feet. Nike also refused to speak when Lantex to negotiate a compromise and avoid the expensive trial. So essentially, Nike is pretty much like, yeah, you got us. We need to stop using this cool compression term as soon as possible, but it seemed like it was dragging his feet and didn't want to negotiate to compromise and avoid the expensive trial. So Nike like pretty much, let's go to trial. This lack of civility goes to the heart of the attorney fee, expense, and signals an improper desire to simply cause increased attorney costs rather than winning on the merits. So it seemed like, again, Nike was trying to bleed these guys dry. Nike, with its far greater resources, did not stop infringing until litigation damages and injunction to deter it and compensate the far smaller resource company occurred. She continued, I'm not understanding what that says. Nike, with its far greater resources, did not stop infringing until litigation. So Nike didn't stop infringing until the litigation commenced, which is, that's crazy. Damages in an injunction to deter it and compensate this far smaller resource company occurred. So it seems like the Lantex got an injunction, which the district court ordered Nike to stop using or selling the product that has this cool compression, which seems like Nike complied. And obviously, the damages, the $791,000 damages, was ordered by Nike to pay to Lantex. The report cited an exhibit that showed Nike threatened to kill Lantex's business by overwhelming it with legal expenses. Nike's incivility, bad behavior, blatant, willful infringement, and reckless, indifferent conduct upon notice of the infringement are rare qualities that distinguish this case from the typical case, and in some credit an unusual discrepancy in the merits. So again, that's the thing that I have an issue with, because typically when you find out that somebody is acting in bad faith, willful infringement, blatant, to me, that means that you're going to get a lot more than $791,000 in damages. But it seems like the court, I'm not sure if it was a jury trial or the court rule, but it seems like the decider of fact didn't think so. So I don't know. I'm going to leave it there. So what do you guys think? I mean, again, first and foremost, kudos to the small guy, Lantex. Hey, anytime smaller companies, especially when they know they've been wrong and it's proof in the pudding, regardless if it's a big company such as Nike, the fact that you take it all the way with them, again, seems like you're going to get the $7 million in legal fees, which is a great thing. It seems like you probably should have got more than the $791,000 in damages, but again, you got something, which is a good thing. And again, your trademark is strong as a result of you being able to just think about that. You go to court against a behemoth, against Goliath, Nike, and not only does the district court, but the Court of Appeals rules in your favor as it relates to the validity of the trademark. That trademark is, it's a pretty strong trademark, you would imagine at this point. But again, at least you guys got something. It seems like based on the special master report, the district court, I'm not sure if the judge ruled or gave the damages, or if the jury had, you guys had a jury trial. But it seems like you probably should have got more than $791,000 in damages. But again, going back to my original point, my opening to this video, it's a dirty business. But if you know without a shadow of a doubt that somebody is doing wrong by you, regardless if it's a big company, man, take them to court. You cannot be afraid to sue the big company. And again, now just think about that. Companies are probably not going to mess with this cool compression trademark, nor are they going to mess with Lantex, because they like, man, this company, they're going to take us to court. They're willing to sue us if we infringe this mark. And it seems like, again, they were victorious. So this kind of puts everyone on notice. So it can be some good things that come out of this. You guys have to let me know what you think in the comment section. Please hit the like button. Please hit the subscribe button if you haven't already. I'm trying to bring you guys these current events. And I thought this was a good one, because a lot of these comments I've been getting on these previous videos as it relates to, oh, they just a little guy. The little guy typically won't win versus a big guy. They'll be bled dry. It's like people were just giving up. So I love the fact that it's a win for the little guy. And again, it seems like you guys should have got a little bit more money in damages, but that's a conversation for another day. Please hit the like button. Please hit the subscribe button. Let me know what you think about this case in the comments. And Man, I'm gonna have to try to get the attorneys or the CEO or something for Luntex on the channel to talk about this one. Till next time, peace.